gonna just meme about. Okay.
However bad you think it is, it's worse.
No.
Remember when Trump's lawyers argued that he could SEAL Team 6 as political rivals, and we all laughed because that's a preposterous thing for anyone to argue, and absolutely no serious person could possibly believe that the Constitution or the laws of this country would allow that to be the rule. Well, the Supreme Court just said, hold my beer while I assassinate my political rivals.
The president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold.
Yes, the Supreme Court has effectively given law-breaking presidents, and we're not singling any one law-breaking president out or anything, could be any felonious president, almost absolute immunity from criminal prosecution. And where the court did not grant outright absolute immunity, it gave presumptive immunity and procedural protections that might as well have been absolute immunity. And while unofficial acts of the president still receive no immunity, the crap cherry on top of this crap sundae is that even though a president now has immunity from criminal prosecution for official acts as president, a prosecutor cannot even use official acts as evidence in a prosecution over unofficial acts, which makes prosecution of some unofficial acts virtually impossible. Whether you are a Republican or a Democrat, this is a terrible decision for democracy, possibly a top 5 worst Supreme Court decision of all time. But just how bad is it? Justice Sotomayor says, quote, the court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law,
we've already read all this shit.
Justice Sotomayor concludes that the opinion marked a sea change in the relationship between the people and the president. Quote, in every use of official power, the president is now a king above the law. But how did we get here? Well, until now, executive immunity was a court-created doctrine that shields presidents from most civil lawsuits involving conduct that occurred during their presidential terms. There's no explicit constitutional text granting the president immunity. The court explained that it was, quote, settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the president of the United States. To determine whether a particular type of suit against a president or a former president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. So until now, virtually every lawyer and judge in the country assumed that while executive immunity would shield civil lawsuits because the president could be sued by almost anyone in the country over almost anything, that criminal prosecutions would be different. Why? Because it's way more important that a president be bound by criminal law and not commit heinous criminal acts, even in service of their duties. Plus, there are way more safeguards against criminal prosecution than civil suits. The circuit court ruled that presidents are not above the law. Quote, the president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. Quote, on remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the opinion starts with the premise that presidents have lots of power, powers they wield exclusively and do not share with Congress. The court describes the president's core powers as taking care that the laws are faithfully executed, commanding the military and dismissing officers he has appointed, and pardoning people who have committed crimes. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any intrusion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient.
Wait, hold on. Holy shit. I just had a fucking brain blast to fix this entire problem, but probably wouldn't work. When Congress asks for records, or when Congress makes requests for information from people, is that considered like a subpoena? Like when the January 6th committee was doing stuff, is that considered like a subpoena for, is that considered like a subpoena for like criminal purposes, or? Because what I was going to say is, what if the only way to hold the president criminally liable, I'm trying to think if this would work, would be through the impeachment process? Meaning that, let's say that you think that Donald Trump is engaged illegitimately with one of his core powers. So you impeach him, and then in the hearings in the House and the Senate, you make public on the record evidence of him doing wrong things, so that afterwards, if you did want to criminally prosecute him for some other action, you could cite these things on the public record that would have been made public during the impeachment process, rather than citing or investigating or subpoenaing Trump himself. One of the things that Roberts says in his decision when he's talking about Barrett is, Justice Barrett disagrees, arguing that in a bribery prosecution, for instance, excluding any mention of the official act associated with the bribe would hamstring the prosecution. What the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself. I don't know if this would actually work in practice, but I don't know. All right, sorry.